Could you be prosecuted for growing marijuana on your own? It's possible. In this video, we're going to explain how. Any adult, someone 18 years or over, who is growing more than 6 marijuana plants or cannabis plants can be prosecuted for doing so. This is largely governed under California Health and Safety Code 11358. If you look this code section up, you're going to see it's quite complicated. It has a lot of different layers to it. I'm going to focus mostly on subsections C and D of this law. Basically, you need to have the right type of license or permit to be compliant with California state regulations to grow marijuana on your own. If you don't have that and you're growing more than 6 plants on your own, you could be guilty of a crime. Now, on its own, illegal marijuana grow is a misdemeanor under 11358C. The maximum punishment is 6 months in county jail. How can it be prosecuted as a felony? This is where we get to subsection D. There are situations where the defendant has prior felony convictions or prior convictions for sex offenses under Penal Code Section 290. There are also situations where the grow operation involves certain types of illegal diversions of water or irrigation. That's also laid out within subsection D. But the general thrust of this is that even though recreational marijuana is legal in California, it is still subject to a host of regulations. And one of them is that while you can grow recreational marijuana on your own, you're limited to 6 actual plants. And how do they define growing under this law? Well, it's planting, growing, cultivating, drying, processing, or harvesting. Those are all the terms that Health and Safety Code 11358 lays out. The typical case that we often see is perhaps a grow house case that we hear about, where a structure is being used, whether it's a home or some other, or a greenhouse or something, to illegally grow marijuana. The people don't have the relevant permit, they're not otherwise compliant with state regulations, and they have more than 6 plants that are being grown. A common defense that we have to inspect in these kind of cases is, how did law enforcement find out about the operation? Did they get a warrant to search the premises? And if so, how did they get that information? Is that information itself illegally obtained? In one previous video, I discussed a situation where they found a very involved marijuana grow in our client's house, or the house they were staying at. And they got a warrant to search the house, but the warrant was all based on information that was itself from a warrantless entry by law enforcement. In this situation, the warrant itself was tainted. We were able to get the evidence suppressed. Good criminal representation involves defense of all angles, exploring all of it. And definitely illegal search and seizure is a big one in these kind of cases. Another common defense is the defendant merely present at the location. What are their actual ties or connections to the property? Or is the grow going on in a certain subsection of the property, maybe a housemate who keeps to themselves, that maybe the defendant living in another wing of the structure has no reason to know about? These are all things that need to be litigated zealously in the defense of an illegal marijuana grow operation, along with a thorough inspection of the elements of the offense that I just laid out. And also, if you're facing misdemeanor allegations for violating Health and Safety Code 11358, is it possible that maybe, at a look at the police report, is the defendant subject to possible penalties as a felon because of the water diversion involved, or maybe because of their prior record that maybe the DA doesn't know about? Maybe in that situation, it might be effective to jump on a misdemeanor resolution at the earliest opportunity before it gets worse. All these options are at play when defending a charge of violating Health and Safety Code 11358. If you need any help, just check out our Instagram page or our YouTube feed. Thanks, and stay safe out there.